Hi, I'm Jeff Wagener, attorney with the Civia Law Firm. I'm going to talk to you today about 10 tips for making solid business contracts. Make sure you get the contract in writing. Although oral contracts are enforceable in many instances, it's always a good idea to get a business contract in writing where the parties' obligations can be clearly spelled out and you can avoid confusion. Keep it simple. You don't need long contracts. You don't need complicated verbiage. You need simple, concise terms to spell out the parties' obligations and rights under the agreement. Deal with the right person. Make sure you're negotiating with someone who has the authority to bind the entity they represent. Don't negotiate with someone who has to go get someone else's approval before agreeing to a term. It causes confusion and misunderstandings when the document is drafted. Identify each party correctly. Sometimes you're dealing with an individual, sometimes you're dealing with a corporation or an LLC. Make sure you have the correct designations. That's crucial. Spell out all the details. Don't assume that you can leave things open for future discussion. Make sure you have everything in the contract that needs to be in there. Think of every contingency you can think of and make sure it's a complete, thorough contract that will avoid any confusion in the future, because judges look to the four corners of the document when they decide what the parties' intentions are. They don't often look outside of the document itself. Specify payment obligations. Payments are often one of the most problematic areas of a contract when there's confusion about how much is to be paid, when it's to be paid, and to whom it's going to be paid. Make sure the terms of payment are clear, and make sure the payee is clearly spelled out who the money is paid to, and the timeline for the payments, and what happens if payments are late, if there's any penalties for that. Agree on when and how the contract can be terminated. Can either party terminate the contract at any time given a certain number of days notice, or can it only be terminated upon a breach by one of the parties? That's an important term that needs to be included in the contract. Agree on a way to resolve disputes. Will you opt to have arbitration or mediation as a way to resolve the disputes, or do you prefer to go through the judicial process and let the courts decide? There are pros and cons to both, but make sure it's spelled out in the contract how you'd like to have that happen. Choose a state law to govern the contract. This is important when the two parties to a contract, two or more parties to a contract, are from different states. We want to make sure we know what state law is going to govern in the event there is a dispute. You also want to make sure, if you choose arbitration or mediation, that you mention in the contract where that's to take place, both the city and the location of the arbitration or mediation. Keep it confidential. When you're dealing with business relationships and business contracts, you'll often have access to the other party's confidential information and vice versa. You want to make sure that there's a mutual promise in the agreement that any kind of confidential information that is shared with the other is kept confidential. Finally, I want to say a word about why you should always have your contracts reviewed by an attorney. It's good to do that because you want to make sure that the terms of the contract that is drafted are lawful and can be enforced. It also helps you prevent misunderstandings before you sign the contract. And it also reduces the chance of future litigation. If there's any issues the attorney can spot, and those can be discussed between the parties and corrected or modified or clarified, that's always a good thing to do so that in the future litigation will be less likely. I hope you enjoyed my discussion today on 10 tips for making solid business contracts. I thank you for your time.